Hearsay evidence means a statement made by a person who did not personally see, hear, or experience the fact but learned about it from someone else. Example. A says in court, B told me that he saw Ramesh committing theft. Here, A did not see the theft himself. He is only repeating what B told him. Therefore, A's statement is hearsay evidence. As a general rule, hearsay evidence is not admissible because the original speaker is not before the court. The statement cannot be tested through cross-examination. There is a greater possibility of mistake or falsehood. However, the Bharatiya Sakshya Adhiniyam 2023 recognizes certain exceptions where hearsay evidence becomes relevant and admissible. 1. Dying declaration. A statement made by a person regarding the cause of his death or the circumstances leading to his death becomes relevant after his death. Example. Before dying, A says, Ramesh stabbed me. If A later dies, this statement is admissible as a dying declaration. 2. Res gesti, facts forming part of the same transaction. Statements made during the occurrence of an event or immediately connected with it become relevant. Example. During an assault, B shouts, Ramesh is attacking me. The statement is admissible because it forms part of the same transaction. 3. Statements made in the ordinary course of business. Statements made by a person in the ordinary course of business, professional duty, or official duty may become relevant when the maker is unavailable. Example. Entries made by a deceased accountant in business records regarding payments received. 4. Statements against interest. A statement made by a deceased or unavailable person against his own financial, proprietary, or legal interest becomes relevant. Example. A deceased person had stated, I owe 50,000 rupee to Mohan. The statement may be admitted because it was against the maker's own interest. 5. Statements relating to public rights, customs, or general interests. Statements made by deceased persons regarding public rights, customs, traditions, or matters of public interest become relevant. Example. Old village records showing that villagers traditionally used a particular pathway. 6. Statements relating to family affairs, pedigree. Statements concerning birth, marriage, adoption, relationship, or family history made by deceased relatives become relevant. Example. A deceased grandfather's statement regarding the legitimacy of a family member. 7. Evidence given in earlier judicial proceedings. Testimony given by a witness in a previous proceeding may become relevant if the witness is dead, cannot be found, is incapable of giving evidence, or cannot be produced without unreasonable delay or expense. Example. A witness gave evidence in an earlier case and later died. His previous testimony may be admitted. 8. Expert treatises and law books. Statements contained in recognized expert books may become relevant when the author cannot be examined. Example. A medical textbook written by a recognized expert may be referred to in a medical dispute. Simple case study. Suppose Sita suffers serious burn injuries. Before dying, she tells the doctor, My husband Mohan poured kerosene on me and set me on fire. The doctor later testifies in court about Sita's statement. Normally, the doctor's testimony about what Sita said would be hearsay. However, because the statement relates to the cause of Sita's death and she has died, it becomes admissible as a dying declaration. Thus, although hearsay evidence is generally excluded, it becomes relevant under specific exceptions recognized by law. Conclusion. Hearsay evidence is generally inadmissible because it is indirect evidence. However, it becomes relevant in special situations such as dying declarations, res gesti, statements made in the ordinary course of business, statements against interest.